Good morning, ladies and gentlemen. My name is James Wright. Thank you all for coming today. As the stakeholders into the inquiry for the effectiveness of workers' compensation law for injured workers with prolonged impairment, I'm aware that you guys have suffered a degree of permanent impairment and are injured workers yourself. So I apologise if getting here today was in any way difficult. So, an introduction into the law of negligence and why this matters to workers. The Workers' Compensation Rehabilitation Act governs Queensland state laws in relation to the no-fault scheme and the action negligence between a employer and employee. So the current state of liability, as you can see on the screen there, is the duty of care owed is generally recognised. Employer-employee relationship is generally recognised by the law, and that's what moves the worker from claiming under the Civil Liabilities Act into the Workers' Compensation Rehabilitation Act because of this, because of the nature of the relationship, and also some definitions around injury and that sort of thing. We'll look at that a little bit shortly. Breach and causation mirror the Civil Liabilities Act in terms of content. They are basically the same thing, and the onus of proof rests on the claimant, on the injured worker. Now, in this presentation, we just kind of looked at the state of liability, but that's not necessarily the main topic of this presentation. In this presentation, we'll be looking at where the law works well, and it does. And we'll also be looking at statutory claim outcomes as well as common law outcomes, and whether or not there are any economic contentions that injured workers face when they are electing which avenue of compensation they wish to take, and we'll talk about election very shortly. So we'll be talking about those provisions. We'll see hopefully some deficiencies that injured workers experience in the law surrounding workers' compensation. So some history of the Workers' Compensation Act. So there was before the current state of the legislation now a different avenue that injured workers could take if they couldn't prove an action negligence, and this will be important when we talk about elections and degree of permanent impairment. And basically, Burke and Power Serve Proprietary Limited, and it was later affirmed in Parry and Woolworths Limited, the Queensland Court of Appeal upheld the decision that there's an alternative route under the Workplace Health and Safety Act if they can't prove negligence in a common law action. And that was overturned in the amendment in 2015. It's important to take a look at some definitions. The definition of injury under Section 32 of the Workers' Compensation Rehabilitation Act is a personal injury arising out of or in the course of employment if employment is a significant contributing factor to the injury. This raises some contentions in psychiatric and psychological harm claims, and the reason being is those types of injuries manifest over time, and it's very hard for a plaintiff to prove that arose out of or in the course of employment. Now, there have been some developments in the law in relation to service workers and reasonable foreseeability of psychiatric harm on that duty of care has been placed on employers of service workers. The definition of worker under Section 11 is A, works under a contract, and B, in relation to the work, is an employee for the purposes of assessment for PAYG withholding. This raises contentions in the duty of care state of liability, and this is it's not relevant for our purposes, but it raises some issues in relation to some contracts of employment and whether or not an employer owes a duty of care to an independent contractor. DPI is the degree of permanent impairment, and QOTE is Queensland Ordinary Time Earnings, and we'll take a look at those a little bit more shortly. So let's just take a look at some options that injured workers have. Firstly, a notice of assessment will be given. We'll look at that in just a moment. But that basically produces two types of injured workers, and that is a injured worker who suffers a degree of permanent impairment over 20%, and then there's injured workers who suffer a degree of permanent impairment under 20%. And the effect of this is workers who have a DPI over 20%, they're entitled to statutory lump sum compensation and damages at common law. The only limitation on this is that if they succeed in common law, they pay back the lump sum compensation back to work cover. If you're a worker under 20% DPI, there's a huge limitation here, and that is the election process between statutory lump sum compensation or common law. If you choose common law as a worker under 20% DPI and lose a trial, you are not entitled to any compensation at all. So a little bit more on the last slide in relation to the notice of assessment. The insurer may decide, insurer being work cover, or the worker upon an application under section 132, request that the injuries are assessed to establish whether the injuries have caused a degree of permanent impairment. As stated before, this decides whether or not you fall below or under the 20% degree of permanent impairment threshold. And the reason for this is generally people who exhibit injuries over 20% DPI suffer from continuous pain and suffering from the injury and require special damages for future and past care. So let's just take a quick look into the state of liability and why it's not the focus of this inquiry. The reason being is the coexistence of negligence law and no-fault scheme facilitates injured workers well. 93.5% of statutory claims are accepted within 11.4 days. It's an excellent statistic. Research around injured workers who receive inadequate access to information regarding workers' compensation generally suggests that they prefer to be turned around quickly and provided with as much information as fast as possible, and this is what the scheme is doing. And so it's working quite well in that regard. The establishment of duty of care as the state of liability sort of comes down to the common law aspect of a workers' compensation claim. And it can be quite difficult to establish a duty of care for particular types of employment contracts that establish them as independent contractors and so on and so forth. Now, this area of the law has already been looked at, and some tests have arisen where the courts will look at the contract of employment as well as a control test to see how much control that employer has over the employee, and that will define whether or not that person is an employee or not. And that's why we're not looking at that area of the law. So as I stated before in the last slide, legislation regarding negligence law works quite well. And we have that issue with the duty of care. However, there are common law avenues that can be argued to establish that duty of care. The significant gap that I have found is concerning statutory outcomes and making damages awarded at common law compelling for injured workers under 20% DPI. And that originates from how DPI is assessed. And this will become important when we look at how many claimants there actually are at common law who have a DPI less than 20%. So a little bit more on my point that the law works well for plaintiffs or for injured workers. And you can see that I've highlighted a part in that graph. The payments made at common law total $520.2 million in the financial year 2021 to 2022. And this clearly shows that there are damages being awarded at common law, and we'll take a look a little bit more into that and the incentive behind that for workers under the 20% DPI threshold. The significance of how DPI percentage is measured and assessed directly coincides with how injured workers receive their compensation. After the degree of permanent impairment is established by a physician, DPI can be measured by the annual QOTE value at $1,760.70 times the current standard benefit at 216.15. This represents the maximum standard benefit a worker can receive at $380,575.31. Divide that by 0.01, that gives you $3,805.80 per 1% of DPI. Now that we've established how much 1% of DPI is worth, it's also important to look at how many new statutory claim lodgements that were made as well as common law lodgements made in the last year. So we had 90,000 lodgements and 3,286 lodgements at common law. Of those 3,286, 54.1% of those common law claims had show a DPI of less than 5%. 92.2% of those common law claims show an injured worker's DPI is less than 20%. And this is a worrying statistic because it shows that the compensation provided for these workers who are under the 20% DPI threshold are not receiving compensation that is adequate to serve future and past economic loss. And you can see the standard benefits here. They include general damages. Special damages include past and future economic loss, rehabilitation, gratuitous care, and others. In 2021, 2022 shows the average cost of the standard benefit of the head of damage for finalised claims, as you can see, is $25,000, $25,269. So as you can see, there's a correlation between the assessment of DPI and the compensation amounts associated with each percentage of DPI and the election to go to common law made by workers under 20%. And that is basically they're not receiving enough compensation at the statutory level for their injuries, and so they're going to common law for more damages. And the case of Speziali and Nortask is a great example of this. And Speziali was a case about a man working on a silo who fell 10 meters onto concrete. He obviously had a degree of permanent impairment above 20%. So he got the maximum compensation, standard compensation at the statutory level, which was $355,177.33. And the importance of this is to show that even at above the 20% threshold, the statutory compensation, lump sum compensation, doesn't take into account for future and past economic loss. It only accounts for the losses that are incurred at the time of the injury in relation to medical bills, etc., etc. So, and that's why that law functions well for people over 20%, but for under 20%, it doesn't work great because of that inherent risk that if they lose, which they do sometimes, they will lose their entitlement to compensation, and that's not a good thing, especially given that there's a good chunk of common law claims made by people under 20% DPI. So as I stated before, I think the current state of the law works really well, especially in regards to the state of liability under the elements of negligence. I think that the system as a whole works well, and this is evidenced by the 93.5% of statutory claims accepted in 11.4 days. It's an efficient system, and Queensland remains one of the best in the country. So the reform is based on the breadth of the initial statutory compensation offer and will aim to benefit injured workers who have not received adequate compensation. And this comes from the fact that there are so many common law claims and claimants who receive a DPI under the 20% threshold, and it shows that the compensation isn't adequate at the statutory level. And so plaintiffs or claimants or injured workers would rather risk their right to compensation by going to common law. So a change in the aspects of the scheme should alter and minimise the claims made at common law for claimants under the 20% DPI threshold, and hopefully a review of how the notice of assessment works might also help with this goal, and offering reassessment at the point in time where the worker proactively wants to go back to work, to assess whether or not they're going to have any future impairment and economic loss. So yeah, the allowance of the reassessment of the injured worker could alleviate that stress when deciding to go on the irrevocable election, and they're faced with prolonged impairment, and it would act as a safeguard for these injured workers under the 20% DPI threshold, and offer them access to additional compensation if their injuries persist, which is really important because we can see that there is a significant number of claimants under the 20% DPI threshold risking that compensation for more. So overall, the aim of the reform is to reduce the number of claims made at common law, made by injured workers under the 20% DPI threshold, and in hope that the compensation scheme at the front end of the statutory phase provides more future and past economic considerations when it comes to permanent impairment. So I hope that this was helpful and that you support a reform of this kind. Thank you all for coming and listening. If you have any questions, please feel free to reach out. Thank you.